is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your questions. I'm also here with a great topic. So, the topic I have for you today is your spouse refuses to apply for your green card. Is there anything you can do? The short answer is yes. Now, whenever someone comes to me and they tell me that they have been here in the US for a while, they have been with their US citizen or legal permanent resident spouse, but this spouse refuses to apply for them. That is usually the first sign that there is something that's seriously wrong in this marriage and that there's some sort of one sided thing going on. Because I don't know of any couple who they're genuinely looking out for themselves and they are the one spouse does not want to get the other spouse's green card, especially when getting permanent residence for your spouse means that the both of you can work together to have a better income, have a better quality of life, because the both of you can work, the both of you can have reassurance that you're not going to have to face any types of serious immigration consequences like deportation or even being detained by ICE. And so that's the first red flag that I look out for when I am screening clients in regards to VAWA. And sometimes spouses, and I think it may be something that's cultural, right? Where we are, or we're in a society that believes that you're not being mistreated or you're not being abused in any way because there's no physical violence or there are no threats of physical violence. And I'm shocked to hear some of my clients or individuals that I speak to say that they never hit me. They did threaten violence, but they never hit me, and so that's not abuse. But I'm giving you this information now that under the law and under immigration law, that does those kind of behaviors that they don't involve physical violence, but it does involve your mistreatment, or it does involve being even extremely cruel to you, that does qualify you for immigration relief. And when a spouse is not applying for the immigrant spouse, it usually has something to do with an abusive tendency of that U.S. citizen or legal permanent resident spouse. And that's usually they're controlling. So if they in their heads, they're thinking if they apply for your permanent residence, you're going to be empowered to leave them. So sometimes they'll even comment, if I get you this, you're going to leave me. Or they may believe that if you have this, you can go work. And if you work, you're going to be able to match them in regards to the power dynamic in the household. So they don't want to be able to empower you in that way. And so when I dig deeper, that's what I will discover is happening in the relationship. And we have filed for these cases, and they have gotten approved because of this type of dynamic, where the spouse thinks that if they can keep you from getting the green card, they can maintain the control in the marriage. So keep in mind that if you have a spouse here and your spouse is telling you they're not going to get your green card, that's a red flag. And you really need to start thinking about yourself and your interests. Because when you're here, here without status. It's a scary reality, all right? You don't know. You find that you feel like you're a fugitive from the law. You don't know if the police stopping you while you're driving, or maybe you can't drive because you don't have your license, or you don't know if the knock on the door is going to be ICE. Especially in cases like this, sometimes the spouse will even go as far as to say they are going to call ICE on you. And that does bring a level of fear that I can only imagine, but I do know this happens for my clients. And I want you to know that one, a spouse that's doing this to you, it's not normal, it's not healthy, it's toxic, and it means that they are abusing you. At a minimum, they are subjecting you to extreme cruelty. That's where you need to schedule that consultation and let us talk about it and get that immigration relief. So now what can you do about this, right? Your spouse refuses to apply for you, and usually when the spouse refuses, they have another motive. Sometimes they'll even say something like they don't have the money. And I have seen situations where the immigrant spouse, they have come up with the money to apply and they still will not cooperate with them. So there's usually another motive behind not wanting to apply for permanent residence. And it's usually related to being controlling, being vindictive, not wanting you to be empowered. So if say you're with the spouse, right? And yeah, I know, I can just imagine you may feel like you're between a rock and a hard place. You're still with the spouse. But at the same time, you know that you cannot depend on them to apply for this for you. How can you get relief when you're still with the spouse? Now, this is definitely something that's permissible, because this is a complex issue, right? You may not just get up and walk out of the marriage. You may not get up and walk out of the situation right now. And if you are not ready to walk away, you can still apply for this even when you're with a spouse. Of course, you want to make sure you're safe, because in a case where there is an imbalance between in the power dynamic between the spouses, or there is maybe there are even threats, you don't want to put yourself in harm's way. What I do for clients who are, they want to move forward with their process, but they may still be in a situation where they're with the spouse, we make sure that we maintain confidentiality, that we are very careful with our correspondence. And we also correspond directly with the USCIS. We do in all of these cases, but this is most vital for clients that need to make sure that someone is corresponding with the USCIS while they are focusing on themselves and their safety. And so, yes, even if you're still residing with a spouse, you are still able to file for this immigration relief. And the way that on the immigration side, they're very much aware of the dangers. And so this is why they send all correspondence to the attorney, and the attorney will then correspond with in my case, I correspond with the client to make sure that we can exchange documents safely, and I can provide them updates about their case. So if you're in a situation like this where the spouse is refusing to apply for your green card, I want you to think about this, right? And look at the behaviors of your spouse. Think about what their motives are. Is it putting you in harm's way? Is it stressing you out? Do you want to apply for permanent residence, but the spouse will not budge? This is not a normal dynamic. It's not a normal relationship, and that spouse has a different motive in mind. And so you need to face this and determine how you want to move forward to be able to look out for your best interest. The way you can start is by speaking with me in a consultation. And then I usually go ahead and I evaluate your situation, all the facts involved, and then I determine whether this is a matter that I can take. If it is, then we go ahead and we get straight to work and we make sure our clients are safe while they're doing it. Another thing, though, I want to stress here is, do you have to remain married to this person before filing? Or in order to file it, do you have to remain married? Focus on yourself, focus on your safety. Don't stick in a relationship that's abusive, that presents a danger to you, because you feel as if this is the only way for you to get that relief, is You don't need to do that. You can apply for this even if you're separated. So if you have been, even if you've been separated 20 years, I do have individuals that have been separated for a number of years, and they still qualify for this. Another thing is that if you do get divorced and you finalize the divorce, you have up to 2 years to apply for this immigration relief through VAWA that I am explaining. Now, what this involves is you will be able to apply for your own permanent residence, your own work permit, your own travel document, and all of this will be done over a 2.5 year period. Usually it takes anywhere from 6 months to a year to get the work permit. And then it takes an additional year and a half to be able to get the approval and then move on to the green card phase. But it is well worth it when you want to make it your own process where your spouse is not involved. They're not signing documents on your behalf. You don't have to depend on them to go to the interview, because another thing that I have seen is I have seen spouses go to the interview, the US citizen or legal permanent resident go to the interview, and then they sabotage the spouse. I've seen them go as far as to signing documents saying the marriage was never real. It was never real. The immigrant just you're just helping the U.S. spouse usually says something like they were just helping them out for the green card, and then the officer will have them sign documents saying this under oath, and it turns into a big mess. So if you don't trust, if you're in the middle of the process right now, so it doesn't even have to involve refusing to apply. If you're in the middle of the process and your spouse is giving you vibes like that, like they're constantly saying, oh yeah, you don't want to do that, wait till we get to the interview. You'll see what I won't show up for the interview, or when I get to the interview, I'm going to tell them this was all a fake. If you're getting threats like this, to avoid complications in your matter, just go with your gut. Get legal advice about options you can pursue on your own, because you can switch from the marriage base to your own process. It's not too late. When you get, even after the interview, it's possible, but it gets a little more messy, because by that point, the spouse has already sabotaged the process. The officer has already had an impression on what the marriage is like, that it may be a fake. And so it gets a lot harder to go ahead and submit documentation now saying, well, you are subject to mistreatment. Then the bar is higher to make sure that we can show this type of evidence to the officers. It also gives them something to look back on, because now they're looking at the interview and then they're looking at your new application, and they're going to be determining what's credible compared to is the new evidence more credible than the old evidence, which would be the spouse's statement or what happened at the interview. So very important that you look out for yourself, get legal advice and representation before you do anything. And then if you're in the middle of the process, go ahead and know that this relief is available to you. You just have to take that action to make sure you get legal representation and assistance to get to that point. It can be well worth it. Now, if you would like to get in touch with me, you're going through something like this, go ahead and you'll see the information, contact information going across on YouTube and Facebook, the phone number. Also, there's the link in the About Us and in the description of the video. You can use the link to schedule your own appointment. It's fast, easy, and convenient. So many ways to get in touch with us. Get in touch with us, schedule a consultation. That's the way that you're going to start. All right, so now I'm going to go to questions. Let's see what's going on. So I'm on YouTube, I'm on Facebook, and I'm on Instagram. So if you have any questions at all, go ahead, put those questions in the comments, and I'll go ahead and answer. I'm just scrolling through now to find the questions. Can someone get papers if they entered illegally? Yes, it's a possibility. So this way that I just talked about is one way that individuals still are able to obtain their permanent residence, even though they cross the border without permission. But whether you are going to qualify is going to come down to, your circumstances and facts involved. Um, what if two females got married but nobody changed their last name? So last name it's like a cosmetic thing. It's not absolutely it's not required, right? There are two things that it's not going to make or break your immigration application. I often say the pictures. It's not going to be something, because I've seen people, they fill out the information and they attach pictures. Pictures will not make you get approved. Pictures are like an icing on the cake. After pictures is that it makes it complete, right? You read about these spouses and their life together and what they do and what they share in, what they've achieved together. And then at the end of it all, the officer gets to see all the faces involved. They get to put faces to names, and they get to see the family members, and they get to see every all how the spouses are living in the picture. So after that, they are able to formulate a complete picture of the marriage, to determine that it is a real marriage. But pictures, they're not going to make your case get approved. Like, submitting 200 pictures is not going alone in itself, is not going to make you get an approval. The same is with the name, the last name. And that's really a preference, as to whether you're going to keep your last name. It's a personal choice. It's not a requirement. But if you do, it does show your commitment, but it's not going to mean that your whole application is going to go down the drain because you never change your names. Hi, my I-130 was approved on Friday. Congrats. And we get the welcome letter from NVC. Is it usually this fast? Yes. So at this point, you will get that within days. Things usually slow down after this point, when you pay your fee, your invoice, and you complete the affidavit of support. Then they're going to go through the document reviews after you submitted everything, because you do have to submit an affidavit of support. And then a new application is going to be an application that focuses on the immigrant. And then after that, the NVC is going to go through, they're going to go through a review. And the review is going to then take about, I'm seeing anywhere from a month to 2 or 3 months for that review to come back. You have to be very careful at this stage, because anything that goes wrong can lead to a 3-month delay. Every time you make a mistake, that could be another 3 months added to your process. So just be very, very, this is like the honeymoon phase. And then you go into the phase where it's not very fast. So hold tight. Oh, I'm glad you could catch it too. All right. Okay, so what is Title 42? So it's a health care, public health provision law that was used to keep people out or exclude certain immigrants out. And it was all in the name of keeping the United States safe during the pandemic. But now it's coming to an end. And the controversial part is that it kept people that had real asylum claims out of the country, and it put them at even more risk, because now they're outside, usually at the border in Mexico, waiting to come in. And then, on the Mexico side, they're targeted, they're living in very deplorable conditions, because that they expected to be heard and their claims to be processed at the border so that they could seek safety. Oh, thanks so much, Roderick. How long does marriage-based green card process take? So in the US, it could range anywhere from 5 months and go as long as over a year. If you're outside of the US, I'd say prepare for an 18 to 24-month process. I have a conditional 2-year green card. Can I apply and submit uh, I-130 to petition for my son that is under 21 years? Do I need to include my husband, which is a US citizen, on the application? So that's a very specific question. Usually you are able to still apply petition for relatives, even if you're a conditional green card holder. However, of course, you know that uh, the approval of that relative is going to be based on your approval of the I-751. So you know you have to be careful there. If your case gets denied as a permanent resident, then you're definitely not going to qualify anymore to petition for your relatives. On the other hand, your US citizen spouse can file for your child who is under 21. And if they file right now, it freezes their age so that they won't age out. So that's important if your husband, who's a US citizen, files for your son. But make sure you get legal advice, because remember that the information I'm giving you today is general information. It's not personalized legal advice. This is where it's important. If you are going to go and take action, you need to make sure that you get personal legal advice, because the information here is very general, and I certainly don't know all the facts involved to be able to give you all the legal advice. If you cross the border, can you get your travel document and green card? No, so it doesn't work that way. You can't just come to the border, cross over, and you're going to get your green card and everything you need to live in the United States. As a matter of fact, it may be very challenging. Most people, when they're crossing the border and they get paroled into the country, it's because they do have maybe a good claim to asylum, or there is some other humanitarian reason why they have been admitted into the country. But it does not, crossing the border in itself does not give you access to a green card or the travel document. And it can get quite complicated. So here's the deal: get legal advice, make sure you do that. If you're thinking about crossing the border, you want to know what you're in for. I would want to certainly know all the facts involved. How long does it take for a mother to file for her daughter and grandchild? So if the daughter is under 21, you're looking at about 2 years. If if the daughter is over 21 or over, you're looking at 6 to 7 years. If the daughter is married, you're looking at a 12-year process. Okay, and she's over 21, so that's going to be a 6 to 7 year process. Thanks so much, Ricky, Flossie. I really love that you're enjoying this. This is why I show up. I appreciate your live so much. Very informative. Thanks so much, Shante. I appreciate that. So when Title 42 is lifted, can people still cross? The officers at the border will still process these on a case-by-case basis. So the picture I don't want you to get is, I don't want you to get that you are, when you get to the border, it's an automatic entry. Everyone has a right to legally come to the border and seek safety, of course, but I don't want to oversimplify, and I don't want to make this seem like as soon as you get to the border and you get across, all is well. And I think that's a misconception that many people have, and they end up not fully being prepared for what the journey to the border will entail, and many times they are harmed while they're coming, while they're making their journey from the Caribbean islands or from South America into Central America to get to the border. So while I, as a U.S. immigration attorney, I definitely support anyone who's coming to the border for the right reasons and to legally claim asylum. I just want you to know that just by virtue of getting to the border does not mean that they will let you in. You want to get legal advice. Get legal advice if you are really thinking about making a big step like this. You need to make sure that you schedule a consultation and talk about it, because scheduling a consultation and talking about your particular circumstances can let me understand what's going on to better advise you about what you may expect and what your likelihood is of success should you be able to enter the country at the border. I appreciate your love. I have learned so much where I can give advice to friends based on your information. Great. Thank you for that. And keep in mind, though, that if your friends are they're going to make a move, they need legal advice, they should always do that with an immigration attorney, because not all facts apply to all individuals. And then also keep in mind, this is not personalized legal advice. So all the more important to make sure you get that accurate advice once I can learn all your facts. What's the current timeline when a U.S. citizen petition for spouse and stepson in Jamaica? So I'd say 18 to 24 months right now. All right, so that's going to be it for me. Thanks so much, everyone. I will be back tomorrow at around noon. So I hope to see you then. Thanks for your questions, as always. And I'm looking forward to those questions that you're going to have for me. Bye. Bye-bye.